Hello, everyone. This is Tom Fox, and I am absolutely thrilled to be back today with two of my favorite women, Alejandra Almonte and Sultan. And you are in for a double trouble treat with these two because I'm in for a double trouble treat. And we're going to explore some issues that have come to the fore literally over the past month, but they're going to be with us for a long, long time. So, ladies, first of all, welcome and thank you so much for taking time to visit with me. I'm really looking forward to visiting with you on these specific topics. But first, I'm going to ask you to tell us about your academic and professional background. And I'm going to start with AL because that comes first in the alphabet. Alejandra?
Excellent. Thank you so much, Tom. It really is a pleasure to be here, and the opportunity to talk to you is a delightful one. So thank you for the invitation. So by way of my professional background, I'm currently a member at Miller Chevalier. I chair the international department and also have the privilege of co-leading our workplace culture and conduct practice group with Sultan and our other colleague, Catherine Pappas. I grew up in private practice largely, but I did spend 6 years in-house. I was general counsel for Gate Group's North America and Latin America division. So much of what informs my approach to these workplace culture issues is the experience that I had there dealing with these issues on a daily basis. And you asked for education too. I went to Columbia for undergrad in New York and went to Harvard for law school and have been in DC since 2001 when I started.
Anne.
Thanks so much for having me, Tom. So my background is I went to Columbia for undergrad and for law school, and I've been at Miller Chevalier for 12 years. I, with Alejandra, co-lead our workplace culture and conduct practice group, and I also vice chair the international department at the firm. And with Alejandra, we just recently successfully completed a monitorship related to workplace misconduct issues and governance issues.
So, with that, I'd like to take a look at our first topic, which is the EEOC's new enforcement guidance on harassment. So, who wants to take the start on this one?
I'll start on that one. Thanks, Tom. So when we initially thought of doing this podcast, we wanted to talk about this guidance that had just been rolled out and all of its significance. And in the past week or so, things have changed a little bit. So I'll give the background on the guidance and then talk about what happened since the Trump administration was sworn. So last April, the EEOC released stated guidance on harassment in the workplace. And the guidance is called Enforcement Guidance on Harassment in the Workplace. It was intended to consolidate and replace 5 older sets of guidance from the EEOC on the same topic, going back all the way to 1987, and also to provide some updates to the EEOC's approach to how harassment based on race, color, religion, sex, national origin, age, disability, and genetic information is defined under the EEOC or statute, the EEOC analysis for determining whether employer liability is established in certain circumstances. But on January 20th, the day that President Trump took office, one of the approximately 100 executive orders that he signed was the one called Defending Women from Gender Ideology, Extremism, and Restoring Biological Truth to the Federal Government. And that executive order focuses on ensuring that the United States recognizes only 2 sexes, male and female. The executive order mandates that all sex protective laws promote this position. And among other directives related to gender and its treatment of gender in the government, it specifically directs the EEOC to rescind its April 2024 enforcement guidance on harassment. The EEOC's guidance is, of course, tied to Bill 7, which can't be changed without congressional action, and the 2020 Supreme Court case of Scott v. Clayton County, which protects employees' discrimination on the basis of sexual orientation and gender identity. So I think we're in for a significant amount of litigation that will come about. In the meantime, it's interesting that the EEOC's guidance is still up on its webpage, and the EEOC added a banner across the top that says this document was approved by the Commission on April 29, 2024 by a 3-2 vote. Any modification must be approved by a majority vote of the Commission. So watch this space.
Alejandra.
So I think in keeping with the theme that Anne just laid out, and if the last, 8 days have been any reflection, we're going to see a lot of policy changes. Tom, I think that's a lot of people ask us what to expect. I think for now, we are going to see a lot of policy changes, particularly in this space. And there's a certain, I think, natural and understandable hesitation or apprehension at the beginning of any administration, but particularly with the wave that we're seeing, for companies to take a little bit of a wait and see approach, right? Let's see where things land before we make any decision. And I wouldn't tell them to wait right now, right? I think when it comes to issues of workplace conduct, as Anne just said, the laws that have governed this space, right? Title VII for employers, Title IX for educational institutions, those laws are still in place. Those obligations still apply to employers. Employers cannot discriminate on the basis of any protected characteristic, right? And they're still defined as race, color, religion, sex, or national origin. So it's important, I think, as we hear all of the messaging and policies proclamation on DEI, it's really important for companies not to conflate the administration's change in its approach, the government's approach particularly to DEI, not to conflate that with ongoing obligations and prohibitions that continue to exist under applicable law and under a company's own policies and procedures. Because at the end of the day, if you think about what those laws and policies are really designed to prohibit, it's legal discrimination and harassment. And while certainly by virtue of how that is defined under the law, there is a natural overlap between the law and matters of race and gender, I really think there's a clear distinction to be drawn between efforts to prohibit unlawful discrimination and harassment, as companies have been doing for years, and efforts to, as the Trump administration put it, to, what was it that he said, socially engineer race and gender into every aspect of public and private life, right? That's a direct quote from Trump when he rolled out this executive order. And that's the focus of that executive order, but doesn't override what the law is. So we encourage companies that we talk to right now to continue to operate on the basis of common sense, to take a risk-based approach. Anne mentioned that we anticipate there can be significant litigation in some of these areas, particularly where there may be some gray. But in the meantime, continue to evaluate your policies, continue to evaluate your procedures, and even programs that are related to workplace and employee being, in light of what continues to be the law of the land, which continues to prohibit discrimination and harassment or protect it on the basis of protected characters.
If I could I separate discrimination from harassment and ask you about harassment? Because I can't imagine any rational person who says we have to turn the clock back on harassment. Unwanted touching, from unwanted touching to much worse, to in language that many would find offensive and almost everyone would find offensive. Surely they can't be saying we have to allow that. And hopefully that's not too debatable, but can we still focus on the harassment part and have a robust culture which celebrates its employees by preventing or penalizing harshly harassment?
I think we have to, right? And I love how you put it about celebrating its employees. Much of what drives companies' initiatives is on ensuring that their employees have a safe and secure workplace. And it's exactly rid of harassment in the way that you've defined it, which is the legal definition of harassment. And I would think, Tom, that we should be able to continue to provide those spaces, to provide even programs and initiatives designed to educate employees on what it means to harass and what it means to identify harassment without encroaching on what can become potentially more of a minefield for employers as they navigate where the line between DEI, programs to promote DEI, and programs to prevent discrimination and harassment on basis of race. and gender. And I would think and we're going to talk about, Anne already flagged some of the risks that can arise here, but where there may be an overlap of risk for employer is in trainings and in communications around these issues, where we all understand what a training against harassment looks like, even when you're talking about race and gender and other protected classes, and promoting affirmatively the DEI initiatives that the Trump administration is trying to.
Let me pick up on something you said, and that's a safe space. And I want to try to define that even further to safe physical and safe psychological and safe emotional. And could we take this opportunity to maybe expand the discussion around a safe place or safe space as a part of trying to drive culture in an organization? And if we can't talk about diversity, we can talk about safety. Is that an argument? Not an argument. Is that a discussion you're already having, or is that something you think your clients might be open to at least discussing?
Yeah, it's definitely a discussion we're already having. Companies are sensitive to the fact that the line between physical safety and emotional safety and having a healthy culture is all not just blurred, but intertwined in a way that you can't even pull them apart, because if people are not emotionally safe in a particular way, they're also not going to feel emotionally safe or physically safe necessarily, reporting consistent misconduct, raising their hand to say, I think, something has been wrong, appropriate. So it all needs to.
How would you suggest we've all hopefully everyone on this podcast knows what a risk assessment is, and they understand what a workplace risk assessment is. But how would you suggest a company think about doing that in Q1 2025 as opposed to Q4 2024?
I love that question because, in short, I think honestly companies shouldn't think about it differently in Q1 2025 than they did in Q4 2024, right? So workplace conduct issues, much like financial crimes that we're all used to talking about, create legal and compliance liabilities for companies. In workplace conduct issues can also impact exactly the safety and security issues that we've been talking about, right? So it follows then that just as companies take steps to mitigate risk of financial misconduct and other white-collar misconduct, they should take the same steps or similar steps to mitigate risks that arise from workplace misconduct. And they should do that through very similar methodology that we've seen in risk assessments in other states. And it's important, I think, to flag that risk in the context of workplace conduct can mean several things, right? It can mean legal risk of litigation, it can mean risk of other enforcement, and it means exactly what you teed up for us, Tom, with your last question, the risk of employee safety and being both mentally, emotionally, physically. And I think a very positive approach, and this is where I think it should transition from 24 to 25 and going on, is that employees have been approaching workplace issues not just with legal obligations in mind, really putting a premium on reflecting to their employees affirmatively that they care about their well-being, not just when they're being sued. And so a proper risk assessment in this space is going to allow companies to assess their work environment, try to understand where employees, given where they work, in the spaces that they occupy, might be most vulnerable to potential misconduct. And that can be misconduct not just from peers and colleagues and superiors, but also from a third party, which we also talk about in other compliance spaces, right? And then that information can and should be used to develop workplace programs that are targeted to address and identify those risks. And Anne's going to talk to us a little bit more about some specific guidance on how to do that, on how to conduct it. But if there's just one additional point I'd like to make around this is the value, as companies are weighing the value of a workplace risk assessment. Because I think very often as employers, and I remember feeling this when I was in-house, you feel that you do have your pulse on what's going on in the organization based on reports that you get and root cause assessments of employee misconduct reports, through employee engagement surveys, right? All of those do give us some sense of how our employees are feeling. And they're excellent forms of data. A workplace risk assessment, though, really helps us take a deeper dive into where those vulnerabilities exist and will help you, like to say, look around corners, if you will, about where issues might arise. And it's really a proactive, affirmative way to demonstrate to employees, as I was saying earlier, that you care, which becomes critical in the wake of Me Too, where we see even the allegation of workplace misconduct result in negative publicity, whether it be large-scale reputational damage is what we typically see. That's what becomes top of mind, or the public scandals that are often featured in news reports that tend to garner the most attention. But part of really digging deep into where your risks lie and developing a program around that, I think helps on a smaller scale. In many of the investigations that we've conducted, we see companies grappling with what I'll call it smaller scale public fallout of employees feeling that they're not safe by way of social media posts on websites like Glassdoor that do ultimately affect an employee's reputational harm because they don't have a clean line of sight into all the experiences that are impacting employees in this space.
The Department of Justice, as you both know, I come out of the anti-corruption compliance world. And in that world, we have the evaluation of corporate compliance programs. And in 2020, the DOJ, for the first time, said, you should assess your risk as your risks change, not annually, not biennially, as your risks change. And it was appropriate then because 2020, we were in the throes of a global pandemic. And so there were different risks for working from home. Now, many companies have returned to work, returned to the office, many full-time now. And it struck me in listening to your answer, Alejandra, that the risks are different if you're at the office, and that it may be in a very appropriate time to do an updated risk assessment. And it may even be a more appropriate time to re-emphasize your anti-harassment training, because the harassment that happened online or working from home is very different than potential harassment in a physical workplace. Have you guys been having those types of conversations? And do HR folks understand that assessing risk when they change as opposed to annually or some other specified time frame?
We're messaging it. We're messaging through publications that we put out, through we advise our clients, certainly. And I think, they are starting to understand how they can weave in these efforts into what they're already doing. But you're absolutely spot on, especially if we think about the fact that there are now over 4 years of folks that have been working that graduated in 2020 and maybe for the first time are going to be entering the physical workspace, really reminding people on the rules of engagement at the critical time.
Let me turn to conflicts of interest and workplace conduct compliance. What are some of the recent either agency guidances or agency enforcement actions around conflicts of interest that have caught your collective attention?
Yeah. So the SEC has been focused on conflicts of interest, and that's an area where we take action, at least under the prior administration. Last September, the SEC, in an interesting case, it had settled with James Craigie, a former board member of Church and Dwight, which is a consumer packaging company. And according to the complaint, the Craigie, who was a former board member, had a close relationship with a senior executive at the company. As part of that close relationship, Craigie mentored senior executive. There was more to it than they had a vacation together, and Craigie knew over $100,000 on international travel expenses for the executive and the house. And they discussed confidential information, including videos, impression planning. And the SEC found all of this to be in violation of proxy disclosure rules because Craigie allegedly hid that close personal friendship with the executive from the company, including when he submitted questionnaires used by the company to evaluate whether it was, in fact, an independent director or not. And interestingly, as part of the resolution to those issues, I think the SEC had sought a full ban on Craigie for being a director of a public company. And in the end, he got a 5-year ban and had to pay $175,000 as a penalty. And I think this area of personal relationships and close relationships is also one that has changed during COVID, and how we express friendships and the kind of relationships form and how they form and what people be doing together that could be defined as a close relationship or not might be different from what it was 4 years ago before all of the work from home and COVID related transition started. And I wanted to just make one more comment on the risk assessment factor, because I think this is one area where companies should be evaluating their risks and maybe haven't been as focused as they could be in the personal relationship space. But in terms of specific risks of harassment, the EEOC has a really helpful guidance document on this that I think is worth folks taking a look at. The EEOC a few years ago published this chart of risk factors for harassment and responsive strategies, and it lists 12 risk factors that companies should be looking at. Really runs the gamut from homogeneous workforces to workforces that have particularly young folks in the workplace, or workplaces that have high value and lead. We could talk for an hour on just these risk factors, but I think it's an important document, not just because of the substance of what it has, but also how it lays out the risks. It literally, we had one column where it has the risk factors, got another column lists the addition of the risk factors. So in other words, what to, or then a column on what the relationship is between the risk factor and the ultimate harm that can arise for the company, and then a final column strategies to mitigate a specific risk factor. And I think it's a great framework to think about these issues. Or in-house perspective, I would add some columns on steps taken and deadlines and responsibilities and follow-up. But it's a really good, and you could easily add issues of conflict of interest and other elements related to harassment into that framework to help guide the risk assessment.
Let me see if I can make this personal, at least personal to me. I met my wife at work. We both worked at Halliburton. Halliburton had a written policy on romantic relationships at work for non-executives, and we were both non-executives. And that policy said, if you become involved in a romantic relationship, you must disclose that to your immediate supervisor. If you were in the same group, unit, kind of chain of command, somebody was going to get transferred. But we weren't, so no one got transferred. Do you see that as something that a company can still employ, or have we evolved to no relationships, period? For not executives. I want to leave that out specifically.
So personal to me too, Tom, because I met my husband at work.
Okay.
But to answer your specific question, I think that the short answer is, while companies used to focus really mostly on romantic relationships, and I do think that there is still space for companies to appropriately define what the right policy is for them, much in the way that you've described it is still what we see in companies. Disclose it, make sure there's no line of reporting, make sure that there's no indirect line through which you can influence terms of the person's employment. But what we're also seeing, obviously because of the conflict of interest that can arise from a romantic relationship, but what we're also seeing is that relationships beyond romantic relationships can impact the workplace, particularly if you think about independence of certain roles that need to be maintained in order to protect the workplace, to ensure that there is sufficient amount of separation from a personal relationship to employment decision that need to be made. Much in the same way that you would think about romantic and financial relationships, we also have to think about it more broadly. And I don't want to put a percentage on this because somebody on my team will hold me to it, but I'm pretty confident to say that over half of the workplace conduct investigations that we've conducted contain some element of an actual or perceived conflict of interest that arises from what we would consider to be a close personal relationship that either exists or to colleague around them appears to exist between colleagues. And so this is the part where I have to clarify that I'm not suggesting that there's anything wrong with friendship amongst colleagues. In fact, that's one of our firm's core values and one that holds very near and dear to my heart. So we're not saying you can't be friends with your colleagues. What we're saying is it is important to consider the nature of the personal relationship and how it can influence or be perceived to influence decisions that affect the work. And let me give you just a concrete example that you can see develop, right? So let's say you have an executive who over time becomes really good friends with their employment relations partner, right? Then a complaint comes in that either directly or indirectly implicates the executive. As the employee relations business partner, the friend is probably the person responsible for leading that investigation. There should be a pause put on that to determine whether or not, even if the person is certain they can be independent in investigating the issue, whether or not that creates the optics of a conflict that could impact the integrity of the investigation. And that's a critical question. And I'm not saying that friendships have to be disclosed, but I'm saying that people in positions, what we would typically think about as gatekeeper positions, but in compliance facing roles or decision-making roles, need to have a sufficient amount of self-awareness to navigate and avoid potential conflicts, particularly when it comes to workplace dynamics.
And I'll just add, these are really difficult policies for companies to draft in terms of defining what a personal relationship is or when something has to be disclosed, what exactly would cross the line. So there's a lot of nuance and judgment calls.
Let me change my hypothetical just a little bit. Now let's move to the executive level. And I have maintained that no executive can have a romantic relationship with anyone in the company, period. End of story, end of statement. It is a terminable offense, immediate termination. And that for two reasons. One is the power imbalance and potential conflict of interest. But two is something you just touched on, which is what I call the Andre Agassi issue. Perception is reality.
Yes.
And even if it's a GC and a CFO, the perception is someone made an error in judgment. And so I wanted to ask you guys is about my idea that this is a absolute policy that will be enforced 100% of the time, or do you see it a little bit differently, either from where you sit or the clients that you've served over the years?
So we've seen all forms of policies around. I will tell you that where we have seen companies take a more narrow approach to how they define whether or not executives can have a relationship with people outside of their reporting line, it has caused issues. Even where administratively, from a policy standpoint, they don't have the authority to be involved. Even in one case that I'm thinking about where the person took very proactive steps to recuse themselves from scenarios where they might have been perceived to be in a position to influence their partner's employment, it has caused an issue.
Let me ask you to look down the road a little bit to the extent that's possible. We are now in day 8 of the Trump administration, and it's been as Betty Davis might say, a bumpy ride. And I'm definitely wearing my seatbelt. But can you maybe give us any hints on either questions you're getting asked or sort of proactive guidance you're giving companies and clients to address issues as they may arise that we're not aware of right now, but could easily come up in 2, 3, 6 months? Where do you see us down the road?
Yeah, that's a great question. It doesn't have an easy answer. I think the main advice is to make sure that company is guided by a risk-based, principles-based approach. You don't want to be caught swaying in the wind every day, but establish the truly principles-based approach that is founded in law and in the risks that have been identified.
I would say the same. I think it's kind of themes that we've touched on here is anchoring yourself to what you know remains true as a matter of law, anchoring yourself to company values, company culture that you've built, and policies and procedures that remain true as your guardrail, keeping an eye on what the government is changes that they're making, policy initiatives that they are implementing, and determining to Anne's point of where the risks are for you, right? So right now, companies are on their own rolling back DEI initiatives, right? But the question is, do you have to? That's a question you need to answer on where might there be touch points with the federal government that could expose you to enforcement risk. And that doesn't mean, as we were saying earlier, you roll back every program that's focused on communicating and making employees writ large feel welcome and supported and safe. And within those parameters, you continue the efforts that we've seen so many companies invest so much time and energy in protecting employees from discrimination and harassment and ensuring that they feel that your place of work is somewhere that they feel safe coming every day.
Ladies, unfortunately, we are near the end of our time, but before we leave, I wanted to ask you if any of the listeners wanted to sign up for your great new newsletter or find out more about you all individually, what might be the best place or places for them to go?
I think reach out to us by email. Our emails are on our website, bios, and we're on LinkedIn, and happy to add you to any newsletters.
MillerChevalier.com is the current website where you can find it.
I'm actually feel a little bit better than I did before we started this podcast. You have given me hope. So thank you. I look forward to continuing this conversation with you guys.
And do thank you so much.